G'day guys, sorry about that little change of venue and day. Right, where were we? B. Barton v. Bridgman is on point but explicitly rejects Joden's position. Sheridan, DCJ, District Court Judge, describes it as unlikely construction and observes that there is no basis to read down the rights granted in the relevant section. C. Pate versus Niche Holdings Pty Limited. Dealings with a damaged vehicle, but emphasises that the damage is exceptional, well beyond the expected level of damage for a vehicle of its age and resultant from the non-standard use of the vehicle to transport heavy loads of firewood. D. Hereford v. Automobile Direct Wholesale Pty Limited was decided based on whether the applicant could prove that the supposed breach of the Competition and Consumer Act was present at the time of sale, or instead created by heavy use of the vehicle. The tribunal concluded that, in the absence of more extensive expert evidence, this could not be inferred. Section 2621C was mentioned once by the tribunal, neither analyses it nor comes to any conclusion regarding its interpretation as relevant to the issues in this case. 24. In my view, the interpretation of Section 21C adopted by both the Tribunal and District Court in this case accords with purposive interpretation of the Act, given the legislation's strong consumer protection focus. It is also consistent with the overall scheme of the Act. The right to reject will only arise in limited circumstances, including A. where the failure to comply with the guarantee can be remedied and the supplier refuses or neglects to do so, or does not succeed in doing so within a reasonable time, or B. the failure cannot be remedied or is of substantial character, which includes goods that are unsafe. 25. In many cases it will take some time for the fault to become apparent. Some use will generally be necessary to uncover the kind of faults that the Act is indeed to guard against. After all, if the faults were apparent before the product was used, presumably the consumer would not have bought it. Almost all use of a product, however, will cause some wear and tear. Further, in many cases, as was the case here, one or more attempts may be made to remedy the fault. It may not be until some time after the goods have been returned to the customer that it becomes apparent that the fault has not been remedied. It is reasonable to assume that during those periods the goods will continue to be used by the consumer for their intended purpose. 27. Interpreting Section 20 to mean that a consumer loses their right to reject a product if there is any damage, including damage resulting from fair wear and tear, would result in the right of rejection becoming an ineffective remedy in many cases. That cannot have been the intention of Parliament, given the consumer protection focus of the legislation, which is just their damn interpretation of it. I mean, honestly, if Parliament had intended that the goods could only be returned in new or pristine condition, free from any damage caused by fair wear and tear, then it would presumably have provided for an immediate right of rejection where a statutory guarantee has been breached. Instead, however, Parliament has structured the Act so that the right of rejection will in many cases be a remedy of last resort. Parliament must have envisaged the likelihood of fair wear and tear occurring during a period between sale and of a consumer product and its eventual rejection, possibly following one or more attempts to repair it. 28. Mr. Beard submitted the interpretation of the Act so as to allow purchasers to reject damaged goods even if the damage is only minor damage associated with fair wear and tear, would lead to the undesirable social outcomes by forcing suppliers to absorb the cost of damaged goods. In my view, this is not an undesirable social outcome, but is the outcome intended by the Act. A careful balance is struck between the rights of a supplier and the rights of consumers, as evidenced by the limited scope of the right to reject goods. It is only in fairly narrow defined circumstances, such as where a defect cannot be remedied, is of substantive nature, or remedial attempts have failed, that the right to reject arises. Further, Section 21C still operates to divest consumers of the right to reject goods where the damage is more than minor fair wear and tear. Suppliers do not have to absorb the cost unfairly if the consumers have caused significant damage to the goods. 29. In conclusion, the tribunal and the district court were correct to reject Joden's submission that any damage to the goods after delivery to the consumer, no matter how minor, will result in the consumer's loss of right to reject the goods. That is not what he submitted. He submitted that the SOA went ahead and had a parking accident, damaged the rims, damaged the tyres, which is not fair wear and tear. It is through his neglect of not being able to drive properly. Given his age, I'm not surprised. But, you know, this guy's getting you guys to pay for this civil matter in High Court. Everybody's paying for this guy under legal aid. It is a private civil matter. There is no freaking way, especially when he's got another Mercedes parked in the backyard. There's no way this guy's short of a few bob. Interpreted purposively and consistently with the scheme of the Act as a whole, Section 21C requires that minor damage to goods, such as associated with fair wear and tear, will not result in the purchaser losing his or her rights to reject the goods. Like I just said, it's not normal fair wear and tear to ride up the side of a curb, take a chunk out of the blooming tyre, get a flat tyre. This is a $500+ tyre, plus $700 worth of damage to the rim. That's not minor. It's only because it's a very expensive vehicle to begin with that it makes it even more expensive. So people don't get it. Did the judge make one or more errors of fact? 30. The other three grounds of review set out in 3B, C, and D as above all raise alleged errors of fact. 31. There is no second right of appeal from a decision of the tribunal. It is presumably for that reason that Joden brought this judicial review proceedings. This proceedings is not, however, a second appeal. Judicial review is generally concerned with the purposes of the decision-making rather than the merits of the decision itself. In other words, to figure out whether or not the judge got it wrong, because he's the decision-maker, as opposed to there being a fault in the actual facts of the case. Facts of the case, he's admitted he had an accident. Through his error or omission, he has caused loss to that value of the vehicle. And where there are reasonable grounds for the decision, there is no authority to intervene. If it is possible for a decision maker to have a number of different decisions reasonably open to it, but there may, though rarely, be intervention in the case of an objective, verified, and material factual mistake on the face of the decision. And the material facts or fault in the decision was that good old Judge bloody Harrison, Gary, decided that he's just going to call, you know, riding up onto a concrete curb and causing $1,200+ worth of damage and ripping the bumper off and stuff like that, you know, where it come unclipped from the front fender. That's just ordinary wear and tear, people. So, you know, if you're in a rental car and you drive up a curb, get a flat tyre, cause damage to the rim, rip the bumper off and return it back to the rental company, would the rental company say, oh no, it's all good, that's just general wear and tear? You bet your bloody bottom dollar there's no way they would accept it back without claiming some insurance. But they didn't. The fundamental difficulty for Joden's remaining grounds of the review is that the district court was not required to make any factual findings and did not do so, because Joden's sole ground of appeal in the district court was an error of law, as I have explained above. It was not necessary for Joden to challenge the factual findings of the tribunal. The judge accordingly simply adopted the tribunal's factual findings, which he's not bound to. Let's forget that, not forget that, hey Gary? I'm not bound by that lower level tribunal, really. And focused on the legal issue, which was, and let's remember, good old Ana Tuiava decided that she was going to pull out the dictionary definitions from Oxford Dictionary, and all she did was read out the verb description of damage. She completely didn't bring up the noun definition, which is exactly what it was, causing a loss through error or negligence. But then my legal dictionary definition also says the same thing, through error or omission of the person has caused a loss of value. But no, I mean, they're all using the word damage in their statements, so why didn't Gary go and say, well, what are you interpreting the word damage to mean? Get them to stand on the hot cake, because it shouldn't be up to what we interpret what the word damage is. It should be what the law and the legal definition is. They ignored that. They didn't go to a legal dictionary. They went to this common Oxford Dictionary. That would completely change legislation if everybody started taking the common interpretation of these words. Lawyers wouldn't be needed, would they? Because you don't need them to interpret legalese into English anymore. Moving on. Which concerns the correct interpretation of section 21C. Therefore, Joden is now belatedly seeking to challenge the factual findings of the tribunal in circumstances where it failed to challenge those factual findings in the district court. 33. Joden has now exhausted its right of appeal against the tribunal's decision. It cannot now challenge the factual findings of the tribunal that it could have challenged in the district court but chose not to. Nor is it open to Joden to argue that the judge made an error of fact in relation to the matter that was not before him to determine. 34. It necessarily follows that there is no merit in the three grounds of review that are based on alleged factual errors on the part of the judge. Yeah, because he just decided, yeah, just give it a buff out, it'll be fine. You know, just put a band-aid over their $500 tyre, it'll be good as new. 35. For the same reasons, the judge was correct to conclude that the further evidence that Joden sought to admit for the purposes of the appeal relating to the extent of the damage to the vehicle was inadmissible. Why? It was simply not relevant to the issue on appeal, being the correct interpretation of section 21C. 36. The further affidavit evidence Joden sought to admit for the purposes of this proceeding, which was also directed to the extent of damage to the vehicle, is similarly inadmissible on relevant grounds, even though they accepted my affidavit onto the file. It is not addressed to an issue that is in dispute in this proceedings. Further, Mr. Keane, that'd be me, who purports to be an expert in forensic photo analysis. What a liar. Calling you out, whether that's you, Gary, or you, Sarah, that they're saying absolute untruths. At no point did I ever state that I am an expert in forensic photo analysis. Nowhere. I basically stipulated what my background was, and that I'll read you out my affidavit. That'll be coming up soon. I simply stated what my background was in the lines of technical knowledge, but no, they're saying who purports to. I never purported anything. I wrote it in an affidavit which stood as fact because no one rebutted it, and it was pointing out the errors in the photos that were submitted by the SOA. Moving on. Has no formal qualifications in photo analysis, but rather relies on his experience in producing videos for his YouTube channel. Now, I produce videos for many things. The YouTube channel's just one of them. But here they are trying to, you know, degrade me into some little YouTuber. I'm not satisfied based on his affidavit that he has the requisite qualifications to demonstrate specific expertise or skill in the area of photo manipulation. Yeah, it's simply because I blew up the picture and I've got eyes. You know, I would expect any person with general common sense to see what had happened. He submitted photos that were taken from a long distance away of the whole car. He never supplied close-ups of the tyres. And it was only after the tribunal's findings, John was then allowed to go and inspect the vehicle and get those photos at a later date. In addition, his affidavit fails to comply with the High Court rules, as he does not state that he has read the Code of Conduct for expert witnesses and agrees to comply with that code. Well, I have read it, and I would have been happy to agree to comply with that code, should John's lawyer have actually said, oh, well, you've got to be in for an expert witness, you need to do this. The lawyer charged thousands of dollars and didn't even use his brain. So, yeah, it's ridiculous. Finally, Mr. Keane appears to lack the necessary independence, having apparently participated in the tribunal process as Mr. Murphy's support person. What a liar! I never ever went to any of Mr. Murphy's tribunal hearings. That was another mate, Steve. He went with him to one of them. As I've said before, the first time I knew of this case was in the district court in front of Harrison. And I wasn't there, you know, I came with John, but I wasn't really sitting at the table as a Mackenzie friend or a support person there for him. I just came to observe from a distance. Conclusion 37. In conclusion, the judge did not err in law in his interpretation of Section 21C of the Act. He was right to reject Joden's submission that correctly interpreted. Really? He was right to reject Joden's submission that correctly interpreted Section 20 requires that any damage. So, I'll just read that again. He was right to reject Joden's submission that. So Joden's submission that, they then say, correctly interpreted. So Joden's submission was correct in interpreting Section 21C, requires that any damage, however minor, will result in the purchaser's loss of the right to reject the goods. Interpreted purposively and consistently with the scheme of the Act as a whole, Section 21C requires that minor damage to goods, such as that associated with wear and tear, will not result in the purchaser losing his or her right to reject the goods. Again, they keep going back to this fair wear and tear, even though on record he admitted to having an accident. Accidents, fair wear and tear. I guess that's the pop quiz. 38. The remaining grounds of review, which all alleged factual errors of the part of the judge, are misconceived. Really? Well, how about the fact that he was biased? You know, the last time Harrison was in the district court, when he put in interlocutory application to adduce new evidence, the new photos that they rejected, when he tried to do that, old judgy leaned straight over the pulpit at him and started yelling at him. What part of no don't you understand, Mr. Murphy? That's why John said in the June hearing, I don't want you to jump over the pulpit and yell at me or anything, Your Honour, because he'd already done it in the previous hearing. So he can't have been impartial on an... it's ridiculous. They overlooked that the judge was not required to make any findings of fact. He simply adopted the tribunal's finding of fact, which were not challenged on appeal by Joden. Yes, they fucking were. The whole challenge was trying to get them to comprehend what damage is. That's all it was. I mean, wouldn't a judge of some over 40 or 50 years experience, I mean, he's been around since the Erebus disaster, wouldn't a judge of so many years experience not need to have the definition of damage interpreted? Couldn't it have been nice for him to actually point out to the self-representing litigant what the legal definition is, instead of asking John what his definition is and trying to create a conflict? He's a layperson. It's like getting me, who can't speak a word of Japanese, to shoot over to Japan and interpret what they're saying for everyone else. How the fuck would I know? So how the hell would John know what the legal interpretation is? That's where you'd expect Gary to get it in his head by that point in time what the word damage mean. I mean, he was using the word damage in sentences. Moving on. Result 39. The application for judicial review is dismissed. 40. My preliminary view is that as the successful party, Mr. Prieslip should be entitled to an award of costs on a 2B scale basis. If counsel are unable to agree to costs based on this indication, then leave is reserved to file a memorandum. Any memorandum on behalf of Mr. Preslip is to be filed by the 3rd of May. Any memorandum on behalf of Joden is to be filed by the 17th of May. And that is the end of the decision. So yeah, apparently I was a support person at the tribunal. I lacked knowledge. Apparently I said I was an expert in forensic photo analysis, which I never did. So lied their ass. I mean, they couldn't even get the damage on the car right, saying it was the rear left wheel. It was the front left wheel, because that's how the front bumper got pulled off, you know. If the tribunal had done their job properly and gone and inspected the vehicle at the time of the hearing, there wouldn't be nobody would be having this argument. If they read the papers and what the affidavits were and the sworn testimony from SOA, silly old agent, you can change the word silly to whatever else you want, because he caused an accident, everyone else is now. So I guess it's like I say, if you get a rental, don't worry about it. It's just general wear and tear. Go and see Judge Harrison. He'll sort you out, you know, and don't worry about it. Yeah, fucking legal aid will pay for it all for you. No worries at all. Anyway, guys, I'm out here. See you later.